Good morning, good afternoon, I guess good evening to our European audience. I'm Steve Vladeck, the Charles Allen Wright Chair in Federal Courts at the University of Texas School of Law. Welcome to our webinar on the implications of the U.S. Supreme Court's decision in Dobbs versus Jackson Women's Health Services. I'm really excited to be joined by really four superstar experts to talk about Dobbs and its implications over the next hour. But let me first give a big thanks to Melissa Wasserman, our colleague and the Associate Dean for Faculty Research and lots of other things, who was the brainchild behind today's session, to Andy Martinez, LB Chaithon, and the team of University of Texas AV people who put this together, and to you for joining us. So thank you and welcome. Also, one note before I start introducing folks, there is a Q&A feature on this Zoom webinar. Please feel free to submit questions as the panel goes along. We will do our best to leave some time for them at the end, and I will moderate the questions as they come in. So let me briefly introduce our four panelists in alphabetical order. I could spend the entire hour reading off all of their very impressive accomplishments. I'm going to do the opposite, which is just briefly introduce them and then send you to their Twitter pages, where you can find much, much more about them. So in alphabetical order, Aziza Ahmed is a professor of law as of today at the Boston University School of Law. Congratulations, Aziza. And you can follow her on Twitter at Aziza Ahmed, A-Z-I-Z-A-A-H-M-E-D. Leah Litman is an assistant professor of law at the University of Michigan School of Law, and also, I'm obliged to say, the co-host of the Strict Scrutiny podcast. You can follow Leah at Leah Litman. Liz Sepper is my colleague and professor of law at the University of Texas School of Law at L. Sepper. And Mary Ziegler is a professor of law at the University of California Davis School of Law at Mary R. Ziegler. And I think I am not speaking out of school when I say that they are four of the leading authorities in the legal academy when it comes to the topics for today's discussion. So Liz, home turf, I'm going to start with you. Before we get into all of the implications of Dobbs, why don't we start with the decision itself? I mean, I assume that not everyone has read all 215 pages of what the Supreme Court handed down a week ago today. So what did the majority hold, both as to the existence of a constitutional right to pre-viability abortion and whether stare decisis warrants following Roe and Casey? Like, why are we here?
So Dobbs explicitly overrules Roe v. Wade, the 1973 decision of the court, which first recognized the right to abortion, and Planned Parenthood v. Casey, which reaffirmed that right on stare decisis principles in 1992. And Justice Alito tells us that an unenumerated right, a category that includes things like marriage, family formation, sexual intimacy, must be deeply rooted in our nation's history and tradition in order to find protection under the 14th Amendment. In a single paragraph, he actually rejects the argument that abortion also finds its source in the Equal Protection Clause, which maybe we'll have time to talk about. And he spends a great deal of time in the past looking at the 1800s and how law treated abortion, and concludes that abortion is not deeply rooted. He then proceeds to the stare decisis analysis, right? And he says, well, that really required an assessment of the strength of the reasoning in Roe that Casey didn't do, but that this majority opinion does and finds lacking. So there's 5 factors for stare decisis analysis. He finds that all of them favor overruling Roe and Planned Parenthood. I want to touch maybe just on 3 of them. So on the first, he compares Roe to Plessy, the Supreme Court's separate but equal ruling, as that egregiously wrong. Also say he touches on whether the standard is workable in the abortion cases. Now, he has to fudge things a little bit here because the viability line from Roe, which is really what was at issue in Dobbs, is really clear. Courts have not disagreed on this score, right? It's easy to say you can't ban abortion outright before viability. That's very clear. So he shifts to Casey's standard, which uses the undue burden standard, prohibits states from placing a substantial burden in the way of women. And finally, he looks at reliance and he says no one has ever relied on the right to abortion because no one plans an unexpected pregnancy. So there can't possibly be reliance interests in a real constitutional sense. So I'll stop there, but none of the stare decisis factors favor upholding Roe and Casey, and so they are gone. As of last Friday, rational basis review applies to scrutiny of abortion bans.
So, I mean, Liz, just can you say a bit more about the deeply rooted part of the analysis? I mean, it seems to me that, this is going to have significance, obviously, not just in this context, but others. For those who aren't as sort of deeply versed in the court's jurisprudence, to what extent is this a departure, right, from how the court has looked at other implied fundamental rights? What are some of the key moves that you think the majority makes?
Yeah, so you can find this recourse to history sort of throughout these cases, and Roe itself did look to the history of abortion regulation and practice in the United States, but it didn't stop in the 1800s and went forward into the 20th century. So it's not without precedent to think about the past and to consider the ways the laws treated the past. What's different here is there's no consideration of the time we're living in now, no acknowledgement of an evolution in norms. And as a matter of history, it's a formalist cherry picking version of history, choosing a very particular point in time, and according to historians of the time period, really denies the sort of liberty that women in the 1800s had, in fact, to terminate pregnancies, especially before quickening, before the 16 to 18 week mark.
Great, thanks. I know we're going to come back in much more detail to some of the implications of this analysis. Aziza, I want to come to you. I mean, so Justices Breyer, Sotomayor, and Kagan obviously wrote a lengthy joint dissent. From your perspective, what were some of their central responses to the majority? One criticism of the dissent that I've seen is that it doesn't offer a full-throated defense of the analysis in Roe and Casey as opposed to the principle. Do you think that's a fair charge? And if not, why not?
Yeah, thank you so much. Thank you so much, Steve, also for moderating this discussion, and Liz for setting up the conversation in such a great way. So the dissent's brief was really, really very powerful. They don't hold back in taking on and criticizing positions taken by their colleagues, and they hit on a few really big points. And I'll just outline the ones that stood out to me quickly, and then get to your second question there. But the first thing that's in the dissent, the first, I think, one of the big ideas that's in the dissent is against this notion that the majority seems to be putting forward, that abortion is almost too political to touch, that it's a question that should be left to the states. And to this, they basically say that Roe and Casey also acknowledge the politics of this highly contested area, abortion, that this court is not the first court to stumble upon the idea that abortion is political, but it does disrupt this idea that we have settled freedoms in this country as they name them, privacy, bodily integrity, etc. Second, they take on the claim of neutrality that Kavanaugh really stresses in his concurrence. And this is the idea that the way for the court to be neutral is to basically send the issue of abortion to the states. By not taking a side, quote unquote, they are being neutral. And of course, Kavanaugh raised this in the oral arguments as well. So I think a lot of us predicted it as a part of this decision in the end. But this is a really important point that the court makes, and it opens them up to sort of a more pragmatic analysis of the law to say that actually it's not neutral when you're going to get essentially a parade of horribles here. Women will be banned from traveling. I already see questions about that in the Q&A. The criminalization of abortion, women will be forced to carry pregnancies to term. They talk about forced pregnancy. They talk about women self-harming. They name all this explicitly to say, saying nothing is not neutral, it's damaging and harmful. It matters in a very embodied way for people. Third, and of course, they really emphasize stare decisis. Liz just spoke to that. This idea that precedent should have mattered more, that the court is supposed to take a posture of judicial modesty and humility. That's a quote from the dissent. The court should stay on the path of precedent. And the courts and precedent, they emphasize, says time and time again that a woman's right to choose should be protected. And of course, this is related to the idea of reliance that the dissent also emphasizes, which is that women have relied on the ability to access abortion for decades. And this is something that will now clearly, women cannot rely on this. And finally, and this gets to the history point that you all were just discussing, which is that they offer their own history. And I think, in a really powerful way, they remind everyone that very explicitly that it was only men who ratified the 14th Amendment, that the ratifiers were not attuned to reproductive rights. Of course, they didn't even perceive women as equals. So anything that couldn't be found from this time period then is now up for grabs, and reminded us that applications of liberty and equality should evolve. I would say on the second question about a full-throated defense of Casey, my reaction to that is that I think they know, and I think that we all know, that Roe and Casey are dead now. All we can take is core ideas and principles. I can understand why they wouldn't want to go down the rabbit hole of 50 years of commentary and legal scholarship debates on whether or not Roe was ever even decided correctly to begin with. And so, here I think what they're trying to do is say, we do have a right to abortion. Roe and Casey did set that forward. They set precedent for us. They should have upheld that precedent. And I think by focusing so much on the impact of denial of access to abortion, they are able to set us up for, and of course, Liz mentioned this as well, a more of an equal protection claim in the future.
That's awesome. Thanks, Aziza. So I know we're going to come back to some of those themes as well. I think there could be a little bit of a circle as we get through this conversation. So, Leah, I don't even know where to start. In May, we had, of course, this unprecedented leak of the draft majority opinion. We've heard so much about that leak investigation too. Any day now, they're going to find the leaker. For those who haven't followed this quite as closely, were there big differences between the draft that I think we all probably read back in May and the final version? Were there any differences? Does that surprise you? And if there weren't that many, what does that say?
There were very few differences between the leaked draft opinion and the final version that was released last week. Frankly, I revise and edit my tweets more than I feel like Justice Alito revised this opinion. If you look at the red line, in the portions of the opinion that went into the final opinion, there were no substantive significant changes. There was one passage that was edited where he claimed there is no state constitutional provision or no decisions from the 1800s or 1900s recognizing the right to an abortion. In the leaked draft, he had the words 0, none, and he took those out. And that's literally the biggest change. Now, he did add some things to the draft opinion, responding to Chief Justice Roberts' concurrence, in which he basically called him an unprincipled hack, for not completely overruling Roe and Casey. He also had some passages, angrily responding to the dissent, and their accusation that the majority was jeopardizing other rights as well. But in those passages, he just basically reiterated stuff that was already in the opinion rather than engaging with the arguments. Was this surprising? It does depart, at least from what my experience was when I was clerking at the Supreme Court, 10 years ago. The justices did actually revise opinions in response to comments from their colleagues in response to separate writings. And here, Justice Alito not only had comments from his colleagues, he had comments from the entire public that saw this draft opinion and pointed out, a bunch of overstatements or where it was glossing over nuance and complexity. And he just didn't address any of it. I guess, what do I make of this? On some level, I guess he thinks he's infallible, but more seriously, I think it reflects a really concerning dynamic that has both given us the court we have and also tells us where this court might go, which is the justices live in a closed universe of their own ideological making, where they do not think they have to listen to people with opposing views. They have divided up the world into camps, and they just don't think they have to take seriously, the worldviews of people who don't share their ideological priors or who don't agree with them on these cases. And I think that makes it much easier for Justice Alito and his colleagues just to write off, legitimate criticism or pushback as just frankly irrelevant.
That's it. So I guess that's interesting. I mean, it strikes me that we might sort some of the public reactions, right, to the draft opinion as falling into sort of a couple categories, right? One, like, I can't believe they're doing this criticisms, and one, like, this is actually incorrect criticism, right? Like some of the reliance on Matthew Hale, right, among other things. I guess I was surprised that the second category, that we saw no movement there, right, where sort of obvious areas where it seems to me that the opinion could have been shored up, right, that didn't appear to be followed and paths didn't appear to be taken.
But I think that is, or at least the decision not to revise the opinion to reflect the fact that some of the historical sources were, let's say, overclaimed, the decision to rely on some sources, when there might have been better ones, or again, the decision to gloss over the fact that there were differences in how abortion was treated before and after quickening. Like, all of those got kind of ignored. And I think the reason they did is it reflects the views of a justice who believes a lot of the criticism is coming from people who just don't share his views and is therefore in some type of bad faith, and he doesn't have to listen to it. I think that's an extremely dangerous world for us to be living in, where even when, basic mistakes are pointed out to you and people are telling you, if you revise the opinion, it would be stronger, the justices won't even listen to that simply because they think it's coming from someone who doesn't agree with them. Like, that's not judicial. It's not judicious. It's concerning.
So, I mean, I guess one last on this before I bring in Mary. I mean, so it seems to me that another part of the story here is I don't think, I suspect neither you nor I think Justice Alito has changed in that respect, right? That this is more about how he no longer has to appease some other justices to keep his majority, right? And so I guess, is that as much a reflection on Justices Kavanaugh and Barrett, right, as it is on Justice Alito?
Oh, absolutely. I think it is a reflection on every single justice who joined the majority, rather than encouraging Justice Alito to revise the opinion, again, in light of the spectrum of very fair criticism that wasn't in the register of your conclusion is wrong, but my goodness, why are you making these claims about the historical record when it's so much more complicated? Why are you relying on Sir Matthew Hale when he sentenced women to die for witchcraft? Could you pick an alternative source? And he just didn't care. And neither did any of the justices who joined the majority, enough to suggest that their join depended on him, reflecting some complexity somewhere in the opinion.
So this is picking up on a question in the chat. Is it possible that the lack of changes, either in part or, right, that along with everything you suggest, was also sort of a bit of a, we will not be intimidated kind of response from the majority? So
perhaps. I don't know that that is any more of a reassuring explanation to me than a closed ideological universe explanation.
We don't care that we got it wrong. We will not be getting it
right. Like our way of showing you we are independent and powerful is to stick by our demonstrably erroneous claims. That's not great to me either. But I also think, they could have shown you're not going to intimidate us. We're still going to overrule Roe, and wrote an opinion actually engaging with some of the difficult questions, that they just ignored.
So Mary, I think that's a great segue to bring you in. I mean, you are not just a legal academic, you are a legal historian. Help us in that respect to put the decision in perspective. I mean, the result is obviously the culmination of a decades-long project to scale back Roe and Casey and reproductive rights. What does it mean, right, for the court and for the country, right, that at least for now the project has had this massive success?
I think it leaves a pretty clear roadmap for other conservative movements that want to follow the game plan that the anti-abortion movement has laid out. Justice Kavanaugh's concurrence, if you're a historian of this, is replete with the kind of steps in the playbook, right? So one of the most striking things to me was the idea that what matters in terms of stare decisis is that Roe is not settled, right? And not just that Roe is not settled, but that Roe failed to settle the abortion debate, right? That's somehow an indictment of Roe and Casey. I mean, I fail to think of almost any major constitutional decision that settled a question as divisive as abortion, right? I don't know I mean, certainly Dobbs isn't going to settle the abortion debate. Obergefell didn't settle debates about same-sex marriage. So this idea that the court is capable of or intending to resolve national disputes is something that comes from social movement lawyering. And of course, it's sort of a brilliant argument in a way, because you can produce evidence, if you are a movement unhappy with a decision, that it's deserving of being overruled because you're unhappy with it and because you convince state legislators to try to circumvent it or undermine it. It sort of creates a self-fulfilling prophecy as far as stare decisis is concerned. And that, of course, is the work of people who have been trying not just to undermine the reasoning of Roe and Casey, but undermine or reinvent the way we approach precedent more broadly. And so the playbook is there in the Dobbs opinion for people who are interested in undermining other constitutional rights. I think in terms of the message it sends about the court, it's significant, not only as Leah was saying that the court didn't really revise its draft at all in response to a fairly diverse group of critics. It's also telling that the court did this as quickly as it did at a time when 15-week bans were not really a pressing concern. There weren't very many of them. There wasn't a circuit split about their constitutionality. Mississippi initially didn't expect the court to take up the question of the fate of Roe. The court at various moments in this opinion is reaching out to address questions the parties didn't even really fully air, like the fate of equal protection arguments. And so I think that the message this will send certainly to the movement community about the court is that it's open season and that there are very few arguments, if you are coming to the court from a conservative movement, that are not worth trying, whether that's on abortion with respect to the recognition of fetal personhood or on other constitutional rights. And I think it will also convince, and I think this is potentially a more fraught conclusion for conservative movements to draw, but that you can get social changes you want through the Supreme Court, right? That the path to changing America, if you're on the right, runs through the Supreme Court, which is a misreading, I think, of the history of how this happened and a misreading of the role the Supreme Court often can play without other political actors in giving or taking away rights. But I've certainly seen signs of this, that conservatives are hoping that the court will give them a nationwide abortion ban, will take away other constitutional rights, that the court is sort of announcing itself as the guarantor of an entirely different and kind of revolutionary conservative vision of the Constitution. That, as far as it goes, seems to be right, but the court acting alone in kind of isolation as a maker of constitutional meaning is not a great reader of what happened between Roe and now. And I think if people rely on that vision too much, they might find themselves in trouble in some ways that progressives did in the immediate aftermath of Roe.
So I want to pick up on, I mean, you said something there that I actually want to amplify, maybe just because of my Fed courts nerd brain, but you know, the timing of this case, I think, gets glossed over, right? But Mississippi only passed its law in the summer of 2018, right after Justice Kennedy had announced his retirement. So this we never would have gotten here at all, but for the first of the two significant sort of changes in composition. And then it's only after Justice Ginsburg dies, right, and is replaced by Justice Barrett, that Mississippi starts asking the court to actually overrule Roe as opposed to upholding the 15-week ban. And I say this because it seems to me that we ought to underscore the court's willingness to depart from its ordinary norms about, you know, what issues it will decide in a case, about the timing of challenges, right? The justices say all the time in ducking things that we are a court of review, not first view, and yet, and in that respect, right, I think it's also we're talking about the other abortion case the court, one of the two other abortion cases the court decided this term, Cameron, right, where the court went out of its way to allow the Attorney General of Kentucky to intervene to defend a Kentucky law that I guess is now fine because of Dobbs. So, right, that the court is willing to take procedural shortcuts, or at least to allow parties to take procedural shortcuts, right? And I think, Mary, that's really important to sort of what this means going forward. So with regard to, I mean, it seems to me that there are two different forward-looking conversations stemming out of Dobbs. Now, I'd like us to sort of start going down both of those paths. The first is about, obviously, reproductive rights, and there are a whole bunch of questions already in the Q&A that I'd love, Aziza, for you to sort of take a first shot at. Not all of them at once. That would be too complicated. But and then there's the second bucket about other rights. So Aziza, starting with reproductive rights, I mean, what do you see as the immediate implications, and also maybe the more medium-term implications, and what kind of litigation can and should we expect? Justice Kavanaugh seemed to be trying to head off some of these arguments in his concurring opinion. And I guess I'm just curious, how successful do you think he will be?
Yeah, thanks for that question. And I mean, it gives us an opportunity to focus in on how this is going to have some real world impact. And I wanted to just, say that I've been thinking a lot about this book that that critical race theorist Lonnie Guinier and Gerald Torres wrote, basically called Canaries in the Mine, about how the distress of the racially marginalized shows first signs of danger that threaten us. And the reason I keep thinking about that is because so many women, even since Roe, have been living without access to abortion, and they've been fighting for access. They've been fighting to travel to get abortions. They've been fighting to access contraception. And now it's happening to all of us, that idea that we can really predict what's going to come based on how people have been living. And I will say though that I didn't expect it to come so fast. Already we're seeing all the bans, all the but we're going to see the travel bans. This question is in the list of questions here. We're going to see all the trigger laws that are getting enacted, banning abortion. We're luckily seeing a few state court judges, blocking some of those trigger bans. We're going to see a lot of new forms of activism. Crisis pregnancy centers are also going to go virtual. Crisis pregnancy centers have been lying to women about the state of their pregnancies and about abortion laws. They've been defrauding women essentially, and they will continue to do so, I think, online. We're going to see fake portals to get abortion medication. We're going to see false information on the internet. It's going to require a lot of literacy and sophistication on the part of the patient, on the part of the person who wants to seek abortion. And, we've already had a case, NIFLA, of course, that says that we can't actually regulate the crisis pregnancy centers the way we want to. So we'll have to see how this plays out. We're going to see a lot of confusion in the space around fertility, IVF. We're going to see confusion around genetic testing. We're going to have new laws and litigation around how to store and keep embryos. There's already for a long time been a movement that suggests that all embryos are people and they should be adopted rather than destroyed. And I won't say too much about medication abortion because I think Liz might be touching on that soon, but we're of course now in a new realm of new laws that are being passed to ban women from medication abortion. I think what comes with all of this is an increased of prosecutions against physicians. And I think we're also going to see an increase in prosecutions against pregnant women. We're now in a very gray area. How are physicians going to make determinations about when a miscarriage, a woman or a person who's having a miscarriage appears in a clinic, if they had tried to self-induce or not? And this, what was, I think, a narrower set of cases and issues are going to become much bigger and capture many more women. All pregnancies are going to become suspect. So it's difficult to overstate, I think, the impact of this law. But then, of course, like you mentioned, there's also the question of unenumerated rights more generally. And there, we have to think about, and this is, of course, what the majority in Dobbs and Kavanaugh sort of say, oh, no, this isn't about gay rights. This isn't about gay marriage. This isn't. And Justice Thomas.
Swear.
Yeah, we swear this is not about any of those things. And Justice Thomas, as everyone has been talking about, basically said, no, it is about those things too. We're actually going to put it all on the table now for debate and discussion. The dissent says, Justice Thomas is clearly not with the program. They acknowledge that Justice Thomas is breaking off here. So I think there's a big question, you could say, about how these cases are going to fare before the Supreme Court as they, of course, make their way to the Supreme Court now that Justice Thomas is essentially signaling to conservative groups, come one, come all, bring your cases, challenging and undermining the progressive society we're trying to build here. So I'll leave it at that.
So, I do want to get to the other rights piece, but I actually think I want to sort of push the discussion a bit on reproductive rights. Let's talk a bit about travel, because there are already a couple of questions in the Q&A about, whether states actually can ban, people from leaving the state to obtain an abortion. So I'm curious, this is not just to Aziza, but to all of you guys. I mean, Justice Kavanaugh has this remarkably, how do I say, hand-wavy line in his concurrence, which is like, of course such laws would violate the right to travel. So I've been teaching con law for 17 years. The right to travel is notoriously Delphic. There's like, what, 3 cases on it? I'm curious if you guys share Justice Kavanaugh's confidence that the right to travel would protect against those kinds of state laws? Or is it just because everyone knows that his vote is the one that matters the most?
I mean, it's worth saying just that the groups that are, to my knowledge so far, interested in passing laws that might implicate the ban to travel are using SB 8 style, you can't show up in federal court enforcement mechanisms because they're not sure what Kavanaugh thinks either, and they're not interested in going to federal court to find out, right? So I think there's, to my knowledge, and I mean, it's worth emphasizing that, like, if you're studying what the anti-abortion movement is doing, it changed between like yesterday and the day before. So it may be out of date because I'm not paying attention right now. But to my knowledge, there's both an effort in Texas from the folks who wrote SB 8 and an effort from the Thomas More Society. The Thomas More model is sort of based on the idea of trafficking, right? That you're trafficking a fetus from a state where it's protected to another state to be killed. But all of them are trying to say essentially, it doesn't even matter if these laws are unconstitutional, much as it didn't matter if SB 8 was unconstitutional, because you can't go to federal court to challenge them anyway. So I think even if you believe Justice Kavanaugh that this is an easy question, and for what it's worth, I don't think it's an easy question. There people who are trying to pass these laws are trying to make it not matter if Justice Kavanaugh thinks it's an easy question. So I think that I would just say that it's worrisome regardless of your take on Justice Kavanaugh's view.
I just add 3 things to what Mary said. One is that in addition to the organizations that she noted, the National Conference of Life also released model legislation that would restrict travel between states to obtain an abortion. Second is some of the proposed legislation is designed to basically not be targeted at travel between states, but instead just clarify this is a ban on obtaining an abortion no matter where you obtain the abortion, and therefore it's not laws that are targeting interstate travel, and therefore those laws might be less vulnerable to challenge on the ground that they restrict the right to travel, given that they prohibit both in-state and interstate conduct. And the last thing that I would say is, the uncertainty is kind of the point. And so long as there is uncertainty, it is going to chill access to care because people are not sure about their criminal liability as well as the civil liability. And as long as that is true, that is going to deter people from providing or obtaining abortions.
I'll just add as one editorial comment also, even if Justice Kavanaugh is laying down a marker, at least Liz and I are in a state where those markers are not always heeded by district judges, right? And so there's the uncertainty also means you have the specter of lower court rulings, right, that actually uphold these kinds of restrictions as the case makes its way to the Supreme Court. So part of the story, I think, Liz, coming to you is also the medication abortion story. And I love it if you could take a minute first to talk about the difference between medication abortion and surgical abortion. As the one non-uterus holder on the panel, I think there are a lot of us who don't always fully appreciate how very different those things are. But also, can you talk about the increasing prevalence of medication abortion, how that complicates some of these legal battles, and whether, in fact, the federal government might actually have more authority because of the FDA's role in regulating mifepristone than it would have with regard to surgical abortions going forward?
Yeah, so I think I first need to just say how we even think about pregnancy. So doctors calculate pregnancy as 40 weeks. It feels much longer. It is actually shorter because they calculate from the last menstrual period. So that means that the week that someone is having their period is the first week of a pregnancy when they're obviously not pregnant the next week either, maybe 2 weeks plus. So really people only can find out that they're pregnant, say at 4 weeks plus a day, right? If it's the first day of a missed period that's on a 28-day cycle. So in the early portion of a pregnancy, one can take a medication abortion. It's a 2-pill regimen, 24 to 48 hours apart. Depending on the state, you could take it up till 11 weeks. pregnant, right? Again, with that 2-week calculus where you're definitely not pregnant. And now more than half of abortions are medication abortions. And these are medically extremely safe, though legally becoming riskier. And this is distinguished from what we sometimes call surgical abortions, not really surgery. Sometimes it can just be suction. Procedural abortions, still very much necessary for after 10 or 11 weeks, for fetal anomalies later in pregnancy, for various complications that can emerge, and just for later times in pregnancy and for when medication abortion fails, which it can. So until very recently, lawmaking, of course, focused on abortion providers, regulating clinics, often out of existence. But with the rise in medication abortion and during SB 8, which has been in effect in Texas and effectively outlawed abortion after 6 weeks, right? Since September 1st of last year. People still accessed abortion, but they primarily accessed medication abortion. And this, of course, was basically impossible for the state to detect. Very difficult to police, pills that come in through the mail system, right? The federal government controls the mail. But there are attempts. So in Texas, we have SB 4, which already criminalizes medication abortion after the 7-week mark, and also makes it a crime to deliver or mail medication abortion into the state of Texas for the purpose of an abortion. So I suspect we'll see many more attempts to police here, and perhaps attempts now to regulate pregnant people who have, at least in this state and many others, been exempt from criminal prosecution under the abortion-specific laws. Now, so what could the federal government do, right? So one thing, and anyone who says that they have a clear answer on this question, I think is not quite reporting truthfully. The Food and Drug Administration has authority over drugs. So it approves drugs as safe and effective, and has approved medication abortion, and mifepristone in particular. So there are live questions as to whether a state can ban mifepristone for the purpose of abortion. There is almost no case law in this area. There's a Massachusetts case involving an attempt to ban a certain kind of opioid during the opioid epidemic, but really not a lot of case law. So there's some big picture questions, right? Where the state, as with Texas SB 4, has banned a drug for a particular indication because they say it's unsafe. That's part of what Texas says. That contradicts the FDA and would seem to call in FDA preemption. But has Texas really banned mifepristone, right? It's still available for other indications, and so perhaps not, right? Do you require a total ban? Or would this suffice for purposes of preemption? There's also big picture questions. What if a state says, we agree with the FDA that medication abortion is safe? We're not arguing that point, but we view abortion as immoral and we're acting to protect fetal life, right? That would be a very different form of reasoning for a medication abortion ban. Merrick Garland has indicated that he thinks the FDA may, at least in some circumstances, be able to preempt state laws that ban or restrict medication abortion. So we'll see if that goes anywhere and where it goes.
Liz, I hope you don't mind if I follow up sort of on a bit of a tangent, but there's a question in the chat about ectopic pregnancies and miscarriages. And I'm wondering if you can talk a bit about sort of the complications that Dobbs poses in states with bans for how doctors are supposed to and may end up treating both.
Yes, so Dobbs has spurred a run on the penal law, really trying to figure out what it is how states are defining fetal life and how they're defining abortion, because it's clear that in many instances they are not defining either pregnancy or abortion consistent with the reality with medical parlance, right? Abortion and pregnancy are both medical terms. So some states will define a pregnancy or unborn child or the like as from the moment an egg is fertilized, right? So a zygote. Some half of these don't ever implant and even become a pregnancy. Others define pregnancy as that zygote, but it has to be in the uterus. And so then that leaves scope for instance, IVF. So ending a life in the uterus is an abortion, but discarding of embryos in a lab is not an abortion under those statutes. Ectopic pregnancies and miscarriages, Texas has been a bit of a laboratory of democracy on this point, which is to say that even though our abortion law exempts ectopic pregnancies that form in the fallopian tubes, raising real questions then about those that form, for instance, on cesarean scars. There's other forms of ectopic pregnancies. These are not going to develop into viable pregnancies. We've seen hospitals turn away people with ectopic pregnancies, send them to other states, tell them that they need to leave until it becomes an emergency situation. Ectopic pregnancies are always at least potentially emergent because they're likely to fill the entire abdomen with blood, to put a fine point on it. Miscarriages have been deeply problematic because a lot of the Texas Right to Life groups would tell you miscarrying women will not be affected. Wrong. They are defining a miscarriage as being the evacuation of a uterus where the fetus no longer has a heartbeat. But there are many instances of miscarriage where cardiac activity can still be detected. And here we've seen people sent away until they grow septic. This can risk mortality, morbidity, future fertility, and that's what people have been facing in Texas. And in the state of uncertainty, as we've said, hospitals are adopting pretty broad interpretations of law. They're not trying to read it narrowly to facilitate access in urgent and even emergent situations.
Yikes. Oh boy. All right. Leah, I think we could even go down that particular path for another hour or so, but at the risk of trying to move this along a little, part of Aziza already sort of started opening the door to this, but part of what makes Dobbs such a bombshell is not just its enormous implications for reproductive rights, about which I suspect we'll talk a bit more in the Q&A at the end, but its implications for other rights we'd long since viewed as settled. All four opinions in Dobbs, right, speak to this question in some respect. You and I have written about this question, and I guess I'm just curious, who do you think has the better of the argument? What are we already seeing? And I think more importantly, what are the bellwethers, right, that folks should be looking for to figure out, are we moving toward the Thomas view of this issue or the Kavanaugh view?
So Justice Kavanaugh is literally correct that the decision in Dobbs does not formally overrule or change the status of decisions recognizing a right to contraception, marriage equality, or protecting same-sex sexual intimacy. But the dissenters are just right that rights expand and rights contract based on reasoning in Supreme Court opinions, developments at the court, and the opinions of the court. And a few reasons why the decision in Dobbs, I think, projects a future in which decisions on marriage equality, same-sex sexual intimacy, as well as contraception are undermined and chipped away, if not potentially overruled. One is that the reasoning in Dobbs could just be transplanted into decisions overruling Griswold, Obergefell, and other decisions. You can imagine an opinion that says nothing in the text of the Constitution protects the right to same-sex marriage or contraception. There aren't decisions from the 1800s or 1900s or state constitutional provisions from that era recognizing a right to contraception, so on and so forth. You add to that the fact that the majority's opinion says, well, nothing in our decision should call into question those other decisions because abortion is just different and involves the potential for life. But none of that is relevant to the actual reasoning in the decision about why they were overruling Roe, namely the lack of basis in text or history. And if that's right, then the decision in Dobbs seems to boil down to just the majority's assessment about whether it thinks the decision rests on normatively defensible or indefensible views. And we already know, in addition to Justice Thomas, Justice Alito has joined opinions basically encouraging the court to revisit Obergefell versus Hodges. So in my view, there are at least 2 votes on the court for overruling marriage equality. People are just wrong to say there's just one. Other signs of this are, the Attorney General of Texas encouraging the courts to revisit Lawrence versus Texas, the decision saying that states can't throw gay people in jail for having sex, as well as last night at the gubernatorial debates in the Republican primary in Michigan, all of the candidates indicating that they want the court to revisit Obergefell versus Hodges, as well as Lawrence versus Texas. The governor of Utah saying, hey, if it were up to me, I would revisit Obergefell versus Hodges, as well as considerable uncertainty over the last week about whether states could use Dobbs to criminalize certain forms of contraception. It's long been the view of certain, parts of the conservative legal movement and that certain forms of contraception operate as abortifacients, whether that's emergency contraception or sometimes IUDs. Some providers temporarily stopped providing access to emergency contraception because they weren't sure whether they could do so consistent with the state's laws. So as far as what I'm looking for, frankly, those are all indications to me that we are moving toward a world in which states will begin to limit and chip away at some of these rights and eventually start filing cert petitions asking the courts to overrule decisions or create crater size exceptions to them. And so those are some of the things that I'm watching for.
So that's great. Thanks. So I just want on the analysis of the majority opinion as opposed to the political implications, because I think those are 2 not necessarily contiguous things. What would you say to the counter argument that abortion is unique because unlike those other rights, unlike those other interests, abortion is a context in which the state's interest in preserving what Justice Blackmun called, right, potential life in Roe is present, right? That what makes abortion unique and therefore what makes Dobbs unique is the countervailing considerations that arise from the presence of this additional interest. Is that a tenable ground on which to limit the analysis?
No, I don't think so for 2 reasons. One, I think that would just mean the dissent is correct, that all of the majority's opinion is just hypocrisy because nothing that they said about the lack of historical or textual basis for a right to abortion is actually giving them, or a basis to overrule Roe. And second, it just means that the majority is doing some sort of freewheeling interest balancing to decide, what rights are in its views, adequately balancing the relative interests on both sides, or instead getting the balance wrong.
Cool. I have one last question for Mary before we turn to the very active Q&A from the folks who are watching. So Mary, I guess this last question for me is a little bit unfair, but sorry. So what does the ruling in Dobbs tell us about this court? And this actually dovetails with some of the questions in the chat. Right, institutionally, how significant is this ruling going to be in the court's history? If it's an inflection point for the court, where do we go from here, right? For those worried about the court's eroding legitimacy, and or for those who fear that per Leah's, answer, the court may continue to scale back additional rights, is there any ground for hope?
Yeah, I think it tells us a lot about the court's indifference to popular opinion, which I think comes through pretty clearly in Justice Alito's draft, right? That this is a court that's saying essentially, if we think the Constitution means X, we don't really worry too much about whether we're overturning our precedent, which this court has been, I think, extraordinarily willing to do this term. And we don't care if what we're doing is going to be unpopular. And I think that's by design, right? There's very clear historical evidence that people in the anti-abortion movement believed that the court would never overturn Roe unless the justices on the court were no longer worried about political fallout. We're no longer worried about kind of institutionalist legitimacy concerns, that was a necessary ingredient for the overturning of Roe. So the fact that this is the court we have and that this is the court that overturned Roe is no coincidence, right? This is part of the kind of 50 years of work on the social movement side to create the overruling of Roe. So I think it tells us, and it's also probably worth emphasizing that the court's legitimacy, of course, legitimacy we can kind of break down into different buckets. There's legitimacy within the legal community. There's the legitimacy kind of vis-a-vis the public's perceptions of the court. I think there's probably been serious damage done in both of those arenas. But if you're thinking about public legitimacy or legitimacy kind of with the American people writ large, part of the ingredient there would have to be awareness of what the court is doing. And of course, that would be at its peak with Roe, which by most polls I've seen is by far the most widely recognized Supreme Court opinion. So if the court is willing to incur this kind of outcry when the lights are the brightest, it tells you a lot about what the court will be willing to do in matters that are harder to explain to the public or that are less well understood or with cases that are less well recognized. So I think this is a court that's kind of unrestrained in ways that I, as a historian, haven't seen in a long time, maybe ever, but certainly in a very long time. So this is a very different kind of court, not because it's conservative, but because of other ways that the court is behaving. I think in terms of hope, there's always a kind of feeling of finality when the court acts in a matter like this as dramatically as the court did in Dobbs, to say things like, Roe and Casey, as Aziza says, Roe and Casey are dead, which they are in a way, to feel as if the court has sort of taken us entirely off the rails. But I think it's very clear, especially for a historian of Roe, to see the extent to which the court has always been just one participant in a much broader dialogue, to remember that we never entirely just got our rights from courts, even when the court was the kind of mouthpiece articulating those rights, that their creation was always more complicated. And that is still true now. I mean, our rights come from state courts and state constitutions. We articulate rights through statute at the federal and state level all the time, even when the Supreme Court has acted either in announcing Roe, at various points kind of tweaking what Roe meant. It was as part of a much broader conversation. And we've seen as well in the aftermath of Roe that the politics of backlash are complicated, but they can be tremendously generative for movements that don't like what the court is doing. So I think this can be a moment of opportunity, and it's a moment to remember that our rights were never just the product of the Supreme Court, and they don't need to be the product of a Supreme Court that we may feel, or at least I speaking personally feel, is doing concerning things.
Great, thank you, Mary. So we've got 39 open questions in the chat and 7 minutes. I don't even think Leah or I talk fast enough to get through 39 questions in 7 minutes. So let me try to group them into a couple of themes, and maybe the panels can try to be a little brief in our answers, although some of these questions are complicated. Liz, I'm going to send the first sort of theme to you, which is there are a bunch of questions, perhaps not surprisingly, that are Texas specific. If I'm a lawyer in Texas, if I'm a medical provider in Texas, if I am, a human in Texas, what can I do? And I guess, can you speak briefly to sort of what kinds of considerations folks living in Texas should be thinking about as they confront, the next couple weeks, months, right, of reproductive access in our state?
So right now, abortion is legal in the state of Texas. Legislators had argued that a pre-Roe ban on abortion immediately went into effect with Dobbs. Court has sided with abortion providers on that point, at least for right now. There is a hearing on July 12th. So abortion is accessible before the 6-week mark because of the operation of SB 8. In about, I guess, probably 6-7 weeks, a trigger ban will go into effect, which will effectively ban nearly all abortions in the state of Texas. It is a ban on performing abortions, but I will also say that the Texas homicide statute defines an individual and causing the death of an individual. An individual is an unborn child from a fertilized egg onward. So this is a concern for me in that people can, of course, face liability under the penal statute, even if they are not the ones who perform an abortion. So I think it's becoming legally risky. Now, all of these laws exempt the pregnant person. So under these abortion-specific laws, as well as under the homicide statute, pregnant people should not face charges for managing their own pregnancies or pursuing telehealth abortion in another state and bringing a pill back to take the second one here. Now, there are lots of proposals to extend further. Right now, SB 8 includes an aiding and abetting provision. It's an aiding and abetting of a Texas abortion, of a law in violation of Texas SB 8, which are abortions that take place in Texas after the 6-week mark. But there are proposals to adopt other laws that would target people who try to aid and abet others to get abortions outside of the state of Texas. They are not in place yet, but it is a concern, and the concern would be things like speech, right, travel perhaps, and other rights that we have. So I suppose I'll stop there, but lots of legal risks in Texas and states like ours coming in the next months.
And it seems like sort of things are going to change on sort of a day-to-day basis. I mean, I saw this morning Attorney General Paxton going to the Texas Supreme Court to try to wipe away the TRO in the Houston case. Aziza, I'm going to package a couple of these for you. I mean, you had talked about the chilling effect concerns. There are a couple of questions in the Q&A that get at basically whether there are any vagueness-like challenges that might be likely to succeed to laws where the operation of them is so unclear to the person on the street. I'm curious if you have thoughts on the viability of that particular line of legal argument.
Well, I think I always, with all of these abortion cases now, or all of this potential litigation, I always feel like there's two ways of answering. One is, are the laws truly vague? Yes. Are they generating uncertainty? Yes. As Leah said, is the uncertainty the point? Yes. And does it have a chilling effect? Yes. Now, whether or not we actually read a law as vague, though, depends on the political context in which the law is being read. A lot of legal rules that are vague. Think Carhart, for example, at the Supreme Court, the case that banned or that basically allowed a ban on a later in pregnancy abortion procedure. We have to remember that whether or not the laws are actually seen as void will be dependent on, who the judge is that's reading the law and how they want to interpret it. I think that we've entered a new realm of seeing the courts as a new sort of stage in our analysis of the Supreme Court, in which we are willing to sort of see the Supreme Court as a purely political body. And this applies as well to the lower courts, who are going to be these judges that are reading the cases that are determining if something is vague or not. That's going to be the question at every instance. And, I know that we have a tendency to say, okay, it would be better if the courts were acting in a way that made them seem like the institution that they're supposed to be, sort of reasoning well and debating and engaging. But here I wonder if maybe, it's a good thing. Maybe it's a good thing that the court is showing its true colors in this instance. Maybe it'll open up more opportunities for questioning the institution itself. I often tell my students, we're in a moment of questioning institutions, for example, the police, and it's leading to a lot of positive shifts and changes. So maybe the same will happen with the Supreme Court.
Maybe. Leah, I think the last question, or the last bucket of question, I'm going to send your way, and it's about that entity that hasn't really come up much in this conversation, the United States Congress. Right, there are some questions in the chat about whether Congress could somehow codify some kind of protection along the lines of Roe and Casey. Could Congress go the other way if Republicans are in charge at some point in the future and ban abortions on a nationwide basis? What could Congress do today? I mean, I guess obviously there's the political side of this, but can you talk a bit to the con law side as well?
Yeah, absolutely. So if Congress wanted to ban abortions nationwide, it's likely that you would get, I think, a majority of justices concluding the law was constitutional, but on different rationales. Some of the justices would probably conclude that Congress, under its power to regulate interstate commerce, can prohibit abortions, at least those that have some connection to interstate commerce, maybe where people are going across state lines or where you are using devices that have traveled in interstate commerce or something like that. Alternatively, you could get an opinion, say, by Justice Thomas that says Congress is entitled to enforce the 14th Amendment and prohibit abortions because Congress could conclude that fetuses are people entitled to equal protection of the laws. So it's possible, and I think even likely, that there are 5 votes for a nationwide abortion ban on this current Supreme Court. I think what is less clear is whether there are 5 votes on this current court for some sort of codification or protection of access to abortion on the federal level. Given that the Supreme Court in Dobbs rejected the idea that abortion bans violate the Equal Protection Clause, and also rejected the idea that there is any basis for a right to abortion in the 14th Amendment's Due Process Clause, it is unlikely that you would get justices voting to uphold the protection for abortion if they were in the majority in Dobbs on the Section 5, Congress is just enforcing the 14th Amendment rationale. So then you need to get to 5 under the theory that Congress can protect the right to an abortion under its powers to regulate interstate commerce. And here, the justices have been, frankly, selective and, let's say, somewhat unprincipled in how they have applied the court's Commerce Clause jurisprudence. There were almost 5 votes to strike down the Affordable Care Act's minimum coverage provision back in 2012, even though that statute fell well within the scope of Congress's Congress's powers under the Commerce Clause. And so I think it's unclear whether there are 5 votes on the current court for a congressional statute that would codify individuals' access to abortion, even though I believe, that statute would fall within the scope of Congress's powers, and Congress could, if it wanted to, say we are enforcing constitutional rights above and beyond those that the court thinks exist.
Whew. Well, that's quite a lot to chew on. I think we could probably go for another 4 or 5 hours, but on the theory that folks don't actually have the time to do that, why don't we stop it there? I know there are questions we didn't get to into the chat, and I apologize to folks for that, but I'm really grateful to all 4 of you, to Aziza, to Leah, to Liz, to Mary. Grateful to the folks at UT who helped put this on. Grateful to all of you for joining us. And please do stay tuned, because it seems like if there's nothing else you take away from this conversation, it's that this story hasn't ended. If anything, it's barely beginning. So thanks, everybody. Enjoy your Friday, and stay safe out there. Bye, everybody.